everyone. So, myself and Laurel are incredibly happy. I have probably been smiling for days since Justice Susan Himmel from the Ontario Superior Court, after 1 year of looking over the evidence and ruling, she has come to a decision and has acknowledged the invalidation and the unconstitutionality of three sections in the criminal code. I wanted to briefly go over these three sections and why it was such an important decision and what it means to sex workers in Ontario and hopefully Canada when this case goes federal. The first section of the criminal code that I want to bring attention to that was challenged in this case was section 2131C. And what that prohibited was the communication for the purposes of prostitution. What this meant for sex workers, primarily on the street, those working on the street, were forced to limit the amount of time that they spent negotiating with a client. So, what that meant and what that looked like was they were getting into cars quickly, they were working in areas where it is unlit, unpopulated, they were working alone. This law drives sex workers who work on the street into areas that are unlit, unpopulated, and prevents sex workers from communicating properly with their clients for fear of arrest. So they are getting into cars quickly without judging the situation properly. Without being able to judge the situation, might they have been able to if this law was not on the books? The next section that I want to talk about that was deemed invalid and unconstitutional by Justice Susan Himmel was section 2121J of the Criminal Code. And what that stated was living wholly or in part on the avails of prostitution. So, not being a sex worker, I think, and not being involved with sex worker activism, perhaps that law might seem to some to indicate protection from pimps. But there are other sections within the criminal code that are and can be used for that very type of parasitic relationship. And I'm going to use the term relationship very loosely. That parasitic person. This is not, right? What this section was doing was it was saying living wholly or in part off the earnings, living completely or in part off, a live-in partner, driver, security guard, receptionist, other people that you may work with as a sex worker could be charged under this section. This section of the criminal code was targeting those people that are attempting to help us in our profession or work with us or are even just our partners who live with us. People have and do enjoy getting hysterical without reading the laws and so forth, and they may think that this law helped in protecting us from pimps. Well, it didn't. What it did was it criminalized the very people that we were trying to use to keep safe or that we had in our lives, like a partner. Now, the last section that was struck down was Section 210 of the Criminal Code. And what that prohibited was bawdy houses. And defined in the Criminal Code, a bawdy house is a place that is kept or occupied or resorted to by one or more persons for the purpose of prostitution or the practice of acts of indecency. So, what that means is that we cannot work together. Essentially, breaking it down, the definition is so vague, and the law prohibiting bawdy houses so all encompassing that prostitution acts that are occurring in a private space. So, my home, the client's home, will be charged under this law. That could also include simply myself. So, although this law does prevent us from living with multiple people because we can be charged with a bawdy house, it also means that working out of my own space, working in my home, that is illegal. Yet the exchange for money for sex is not in the criminal code. It is not illegal to sell sexual services in Canada, but all the laws surrounding it make it impossible to legally practice our job. And going a step further, not only that, but it causes grave danger for us who are working.